is from daily second class, second April 309 of 2016.
एडिशनल 1 में खाली बना देते हैं, 2 छोड़ देते हैं,
बट 2 भी आएगा
नहीं आएगा।
और हम उसके
You
लिए
see,
हम
there is
नहीं
contrary findings no on that.
हम
उससे
उसके
हम
लिए
further
हम ये बोल रहे हैं कि हियरिंग के समय the court can always answer. Now a problem ये होगा कि when your lordship ultimately hears and then your lordship finds that this was really a question involved, then again इसी के
नहीं,
लिए
ऐसे नहीं कर सकते।
and it is based on Supreme High Patna
नहीं,
High Court rule bench, not the
To what extent one was required to prove and to what extent the evidence was there to prove it, इस पर हम
अच्छा ठीक है
preponderance पे तो
नहीं
कोई
नहीं
ज्ञान नहीं।
preponderance नहीं he
मेरा ये
has
कहना है whether the proof with regard to relationship was as per the standards laid down by Patna High Court is something which we would not like to.
नहीं as per standard के लिए हम नहीं बोल रहे then I have to show that it could not have been based on surmises and conjecture. He has to come to a definite finding that he was the brother of so and so.
There is no finding.
So no, absolutely no. I'll read out that.
खाली आपको finding.
Only एक
अरे
line.
कि अभी ये बोल आप बोले no finding
हम
या भी बोले
हम
definite.
पढ़ दे रहे हैं हम एक लाइन हमको पढ़ने दिया और उसके बाद 1 घंटा पास हम दिखा दें उसके बाद ही
substantial question of law में लड़ रहे हैं आगे क्या करेंगे इसमें ज्यादा टाइम हम नहीं देंगे ठीक है ना इतना रिकॉर्ड हम देख लिए काफी है बताइए
your lordship may come to page 23
और
23 of the appellate court judgment
पैरा नंबर
last paragraph because your lordship I had already pointed out that I had disputed that he was my
yes
brother of at this juncture it is relevant to note that Ticket Murmu was so and so died about 125 years and in page 23 of appellate court judgment last
पैरा नंबर
at this juncture
पैरा नंबर
para would be para 21 का last मतलब para 22 का पिछला वाला पैराग्राफ
पैरा 21 पैरा 22
पैरा 22 से पिछला पेज है
हाँ ठीक है at this time
it is relevant to note that Ticket Murmu or so and so died about 125 years and in the record of right MacPherson so and so 1985 itself the name of his sons is incorporated then it is very difficult for anybody including the plaintiff who belongs to illiterate Santhal community to establish direct relationship between the two brothers as stated above. The relationship of kindred and agnates travels from generation to generation by the elders of the family and villager and they can by their own hearsay knowledge derive from the elders that which so and so. So absolutely. I'll read. Generation to generation by elders of the family and villagers and they can say by their own hearsay knowledge derive from their elders that which of the families of village or kindred and agnates to each other and in the present case in hand not only the plaintiff witnesses but the oral evidence of DW32 and every entry
आप ध्यान से पढ़िए उसके ऊपर वाला पैराग्राफ भी पढ़िए there is a documentary evidence also
नहीं कोई डॉक्यूमेंट्री एविडेंस
आप देखिए ना
हम बता रहे हैं
आप देखिए ना
हम पढ़ दे रहे हैं ठीक है
तो इतना तो नहीं परवर्स नहीं बोल पाएंगे वो नहीं बनेगा लेकिन ये आप
but the court itself Patna High Court that judgment itself says had it been a normal succession I would have no case here is a case where the person
ये apart from such oral evidence there is another documentary evidence to establish that the plaintiffs are the kinders and agnates of the recorded tenant Harmu Murmu
वो कौन सा डॉक्यूमेंट है कोई ऐसा डॉक्यूमेंट नहीं है
C/1
कोई ऐसा डॉक्यूमेंट नहीं है
Exhibit C/1
हम इसमें क्या लिखा हुआ है हम पढ़ रहे हैं
एविडेंस भी है DW2 का oral evidence
Exhibit C/1 and its remark column against plot number 3/3 name of Satpora, son of Ticket Murmu mentioned.
yes
But does it establish that he was the brother? That is what I am saying.
Presumption? Presumption.
No presumption that is wrong. Here, the appellate court itself says that there is absolutely nothing, and it could not have been proved because it was 125 years ago.
Essay number 309 of 2016. The learned counsel for the appellants are present. The learned counsel for the appellant has submitted that submitted a list of further substantial questions of law which fall for consideration before this court as per his submissions. The defendant in the written statement had taken a specific stand in paragraph 9 that as per paragraph number 46 of Gangster's settlement report, the law not allowing female to inheritance under Santhal tribal law was changing owing to force of public opinion, and even during the time of Gangster's survey and settlement, the daughters not married in Gharjamai form also inherited parental properties. He submits that the learned first appellate court in paragraph 12 though has recorded that as per Gangster's report, there are some gradual changes in Santhal custom, but has confined discussion only to the extent as to how a Santhal daughter can be put in Gharjamai marriage and how she became entitled to inherit the property of her Santhal father. The learned counsel has submitted that as per the judgment passed by the Honorable Supreme Court reported in bracket 2013 bracket close 4 SCC 97, the law has been settled that by paragraph 12 and 13
14.
of 12 and 14 of the judgment, 12 to 14. That no custom is valid if it is and submits that the custom is required to be proved and such custom must be ancient, uniform, certain, continuous and compulsory. He submits that the basic ingredients of a custom is not satisfied in the present case, and the learned first appellate court has completely given a go-by to this aspect of the matter. And therefore, he submits that substantial question of law number 1 falls for consideration. With respect to substantial question number additional suggested.
This, Your Lordship, I have not filed, therefore Your Lordship may not.
Okay, only this.
Yes.
The learned counsel for the respondents has opposed the prayer and has submitted that the learned first appellate court has taken into consideration every aspect of the matter, including the rights of female as recorded in Gangster's survey settlement, and therefore, considering the scope of second appeal, no additional substantial question of law is required to be framed in the present case. Here, after hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, and having taken notice of the fact that the first appellate court in paragraph 12 has confined the discussions only to the extent as to how Santhal daughter can be put in her divine marriage and how she will become entitled to inherit the property of her Santhal father. In spite of recording that, as per Mr. Gangster's report, there has been gradual changes in Santhal custom. This court is of the considered view that the following substantial question of law, as suggested by the learned counsel for the appellant, falls for consideration. ठीक है?
Yes.
यही वाला बना देते हैं।
हाँ। Only one.
अब कब पढ़ेंगे? कब करेंगे?
ये वाला तो एग्जिस्टिंग का नहीं करता।
क्या वाला?
कस्टम का जहाँ तक बात है।
बस इतना नहीं बस। Only first question.
नहीं ये वाला एग्जिस्ट नहीं करता इसलिए कि ये जो भी कंजेस्टेड सेटलमेंट में जो 46
देखेंगे ना वो हम आपको सुनेंगे तब डिसाइड। आपको लग रहा है कि मेरा दिमाग क्लोज हो गया, ऐसा नहीं।
नहीं ठीक
सुनेंगे आपको सारा रिकॉर्ड देख के
है कि जो कस्टम
लेकिन ये मानना पड़ेगा बहुत दिनों बाद ऐसा रिटन स्टेटमेंट मिला है कोई इस तरह का प्ली किया हुआ है।
अदरवाइज कोई
आई एम श्योर वो कहां का मैटर है?
बात कर रहे हैं वो कस्टम तो वेल एस्टैब्लिश्ड है बाय जुडिशियल प्रोनाउंसमेंट्स आल्सो।
We will see that. You place all the judgments and you also place all those judgments जहाँ पर इसको कंसिडर किया, जहाँ पे इस पोर्शन को, क्योंकि जब हम वो जजमेंट कर रहे थे हमको नहीं मिला, कोटेशन मिल रहा था लेकिन उसको कंसिडरेशन हमको कहीं नहीं मिल रहा, और उस वक्त हम नए नए जज बन रहे थे, हम यहाँ से डिक्लेरेशन करने में थोड़ा हेजिटेशन था, लेकिन आज वो मैटर मेरे पास आता तो यहीं से डिक्लेरेशन।
नहीं सुप्रीम कोर्ट ने अभी तो इसमें अभी हाल में भी जो है सो उसमें कहा है कि इस मैटर में हम कुछ नहीं कर सकते।
वो सब हम
इस तरह के डिग्री से
कुछ
मधु किश्वार का जजमेंट के
आप
बाद
सारे जजमेंट्स लेके आएंगे।
मधु किश्वार
अब हमें सिर्फ ये डिसाइड करना है whether the customs has been established as per the same judgment। इसके अलावा हम लोग कुछ नहीं लेंगे।
बस उतना ही।
नहीं कस्टम तो इसमें एस्टैब्लिश्ड है, कस्टम एस्टैब्लिश के बाद ही ये जजमेंट आई है, इनका सवाल वो नहीं होना चाहिए।
कोई बात नहीं, आप
इसमें जो सवाल ये चाह रहे हैं, ये जो सवाल रेज करना चाह रहे हैं कि whether a tribal lady or a tribal daughter can have a right like a Hindu or not।
नहीं हम
ये सवाल है,
ये नहीं रेज करना,
which is not permissible।
अच्छा
which is not permissible।
अच्छा कोई बात नहीं, देखिए ये कहाँ का फाइल किया हुआ है, कहाँ का केस है? दुमका रिटन स्टेटमेंट में बढ़िया
मधु किश्वार के जजमेंट में ऑनरेबल एपेक्स कोर्ट ने भी ये इसको इंट्रा वायरस माना, इसको इंट्रा वायरस नहीं डिक्लेयर।
ये हाल discussed Madhu Kishwar also, your lordship. Now because my learned friend has raised the question of Madhu Kishwar, it was never questioned or put before the honorable court that what was the binding custom, whether there was a custom or not. It was
इसलिए आप मतलब for another case maybe it could be a food for thought for another case। जब हिंदुआइज्ड ट्राइबल्स हो सकते हैं तो अकॉर्डिंगली बाकी रिलीजन के भी कन्वर्शन को कैसे हम लोग देखें?
हम इसी केस में
इसमें कैसे हम लोग
दूसरा चीज बोल रहे हैं। Your lordship ने हियर में I'll not say।
ये
हम दो
इशू भी इसमें रेज होगा, ये इशू एक रेज होगा। Can by judicial pronouncement can some other law be directed to be applied? Tribal law is its own law in itself।
Therefore I say there's no law, it is not
those customs since
and
long
Mr. Rahul, in case it is held that they are not governed by this
Travel.
travel law.
Can it be
What will
declared?
be the law which will be governing them?
General whatever would be.
जनरल मतलब किस
Why
टाइप
I say?
नहीं आप थोड़ा
हम
बताइए.
दूसरा भी कर
सिविल प्रोसीजर
हाँ, बता रहे हैं। नहीं कोई ऐसा कोई अदरवाइज सीपीसी में सब कोई प्रोविजन नहीं है. Because in his plaint itself he says that the daughter would not have a right because there is a custom. So if the moment that goes, then obviously inference is that the daughter would have a right. Because if son can have right, why daughter would not have a
To
right?
what extent and how?
Because son would have a right. Natural, whoever is succeeding
She is the only
to the
successor.
absolutely.
No,
So by which law the son succeeds?
Question is that what about the tribal law? That is to be also to be seen.
I say there's no
If suppose
binding
there is
law.
a custom,
There's no
it-
binding.
by various judicial pronouncements, suppose it has been established. So more or less it has a force of law.
कम से कम एक बात पक्का है कि ये केस जाके सुप्रीम कोर्ट में सके.
नहीं,
नहीं,
इसमें
होना
लॉ
ही चाहिए,
कमीशन को
होना
इसमें
चाहिए.
लॉ
That's
कमीशन
what
को
already said.
गवर्नमेंट
आप जितना जजमेंट ला सकते हैं लेके आइए.
ये गवर्नमेंट को इसमें लॉ बनाना चाहिए.
आप जितना जजमेंट ला सकते हैं आप लेके आइए, लेकिन ये इशू इस केस में हम डिसाइड करेंगे. अगर मेरे पास वहाँ बेंच चेंज हो जाएगा तो उसके बारे में आप करना कब बताइए कब करेंगे आप?
Opening.
बताइए डेट बताइए. शर्मा जी को ज्यादा तैयारी करनी होगी. आपको बता दें आपको ज्यादा तैयारी करनी होगी. सारे जजमेंट्स कंपाइल करने होंगे. उसको हाईलाइट करके दे दीजिए. छुट्टी के लिए होमवर्क आपको एक केस में देना. बताइए कौन सा
थर्ड वीक ऑफ
पूरा गर्मी छुट्टी इतना एक महीना हम लोग को मिल रहा है.
हाँ,
हम
नहीं,
तो बोल रहे हैं
opening
9-10 तारीख को.
ओपनिंग वीक. आप छुट्टी में बाहर जा रहे हैं?
ऐसा नहीं, सेकंड वीक में.
अच्छा. At the request of the council for the respondent, the matter is adjourned and is directed to be posted on. सेकेंड वीक से ही तो चल रहा है. सेकेंड वीक तो 9 तारीख से शुरू. सेकेंड वीक 9 जून. 17th in the supplementary cause list. देखिए बड़ी मुश्किल हम बताते हैं. वो छोटे नागपुर टेनेंसी एक्ट का जो मोटा वाला किताब है ना, उसमें है. हम उसी से लिखे थे, इसलिए आपको पता है कि उसमें पूरा टेक्स्ट. वो मेरी किताब जो है लगता है कि हाई कोर्ट में गुम हो गई.
इसमें नहीं है, ये सब किसी में भी नहीं.
इसमें नहीं है, हमको पता है. उसमें पूरा टेक्स्ट है. हम उसको गैंगस्टर सेटलमेंट पूरा पढ़े हैं.
हाई कोर्ट में शायद लाइब्रेरी में हो.
हाँ लाइब्रेरी में मिलेगा वो किताब.
सीएनटी में तो है ही और इसमें तो है.
नहीं, उसमें नहीं है, हमने देखा नहीं. वो है हमने क्या.
ये भी जरा किताब निकालिए. ये मेरे पास भी होगा.
मल्होत्रा बहुत कॉमन बुक है, but only extracts have been mentioned.
Honorable Court want to see the exact text. These are no annotations.
We will see the exact text. Exact text उस मोटा वाला किताब में है
हाँ.
जो राजपाल जी पब्लिश
ठीक,
है.
I have seen it.
है ना, राजपाल जी का
Second
पब्लिकेशन है ना वो.
volume.
सेकंड वॉल्यूम है.
I have not.
देखिए ये केस इसलिए भी डिसाइड करना चाहिए क्योंकि आप लोग दोनों इस सब्जेक्ट के पूरी तरह से जानकार हैं. कोई ऐसा नहीं होगा कि हमको प्रॉपर असिस्टेंस नहीं मिलेगा या आप कोई चीज़ नहीं प्लेस करेंगे. ऐसा सिचुएशन नहीं होगा. हम एज्यूम कर रहे हैं. एंड
नहीं होगा. हम
टेक रिस्पांसिबिलिटी दैट यू प्रोड्यूस
हाँ, सारा जजमेंट है.
एवरीथिंग. ये वाला इनको दे दीजिए. ये जरा देखिए. ये वन अच्छे से कंपाइलेशन फाइल कर दीजिए. The learned counsel for the parties are directed to file short synopsis of proposed arguments along with judgments which is to be latest by 13th of June. आप लोग वो सब जजमेंट्स पढ़िए जो आ रहा है कि ट्राइबल से कैसे शिफ्ट होगा, क्या होगा। अभी आंध्र प्रदेश का आया है, 2 केरला का आया है, 1 शायद चेन्नई का आया
वो
है।
इश्यूज वो इश्यूज में
नहीं है, लेकिन पढ़ने की जरूरत
हाँ,
है।
हाँ ठीक
We
है।
are in a state which has lot of substantial Christian population, Muslim population, tribal population, Hindu population.
सुप्रीम कोर्ट का एक जजमेंट आया जो इनका डेड अगेंस्ट
फाइट करिएगा।
हम सब ले आएंगे, हम इनको इनसे पहले अभी प्लेस करेंगे।
Orders we defect attempt 2, second appeal 691 of 2016.
Yes, madam. 2016 का डिफेक्टिव चल रहा है, इसका हम क्या करें बताइए।
अपील में ना इधर सूट में 1 लाख रुपया दिया हुआ था और अपील में ना 10,000 दिया, यही डिफेक्टिव है।
हाँ बताइए क्या करें।
बस वही करेक्शन करना था,
आपको करना है करेक्शन, कि वहां से होगा करेक्शन।
वहाँ से ही होता है।
Okay. Essay number 691 of 2016. The Learned Counsel for the appellant submits that in view of the office note, the appellate court judgment and decree as well as trial court's judgment and decree be sent to the concerned court for correction with respect to the valuation of the suit. Office is directed to send the judgments and decree enclosed along with the memo of appeal to the concerned court for verification and correction. While sending the enclosures, the office should also indicate the objection pointed out by the office. Post this case on 28th of July.
For admission attempt 6, first appeal 53 of 2025.
Admit. Issue notice to the respondents. Or which requisites under ordinary process be filed by the appellant by 10th of June. The requisites be sent to the concerned court for service through registered process for which the cost be borne by the. आप सारे रिक्विजिट्स ऑर्डिनरी प्रोसेस वाले बना लेंगे
जी।
उसके बाद एक एनवेलप में करके और रजिस्टर्ड का लगा के दे देंगे। अभी प्रॉब्लम क्या हो रहा है कि ऑर्डिनरी प्रोसेस के नोटिस जो हैं वहाँ पे बोलते हैं हमारे तक पहुँचा ही नहीं और सर्विस रिपोर्ट नहीं होता। यहाँ से डिस्पैच के लिए
स्टाम्प लगा के रजिस्टर्ड पोस्ट का अलग से उसमें
रजिस्टर्ड पोस्ट का सारे एक एनवेलप में डाल
जी।
देंगे और वो रजिस्टर्ड पोस्ट का स्टैम्प लगा।
जी।
ठीक है
जी।
इसी तरह से ऑर्डर होगा।
जी।
This is creating a problem in service of notice. इनका appearance record. Post this case on 31st July. Awaiting service. हाँ, call for NCR. Facts से communicate.
For hearing under order 41 to 11 item 7, second appeal 191 of 2017.
this?
Case is that Surjan Bhatia filed a partition suit in 1993. That case was dismissed for the reason that the partition had taken place much before survey, and it was recorded in the survey records. He filed appeal. He went in appeal against that. During pendency of the appeal, he died. His legal years were party. Not on during pendency of that appeal. On 7/12/1998, the elder son-in-law Tahnu Rautia has sold 5 decimals of land in my favor, the appellate. And thereafter,
You were also a party of the family?
No, I was not.
The third party?
हम पार्टी थे ही नहीं. Thereafter on 11/12/1998,
तो आप अपील कैसे फाइल करते?
नहीं उसका अपील नहीं, उसके बाद फिर से एक ओरिजिनल सूट थे.
He sold
Linked hands
5
with-
decimals. उस अपील का क्या हुआ?
That appeal on 11/12/1998, all the parties of that appeal filed compromise petition, and in compromise it was decided that whoever is in possession of whichever land, they will remain in possession and they will not sell it after 4 days of that sale.
ये किस तरह का compromise? Partition suit में they will not sell.
हाँ यही हुआ. This is the fact.
Whoever is in possession will not sell it.
Yes.
Okay.
और 14/12/1998, on the same month, but they had this Tahnu Rautia had executed a cancellation deed, cancellation of the earlier deed of 7/12/1998.
Executed unilateral cancellation.
हाँ, unilateral. Thereafter, this case, original suit was filed by the plaintiff, not this Prasad Rautia, who is defendant number 1, who is respondent number 1 here. He filed the original suit for declaration that the sale deed dated 7/12/1998 was null and void.
Was null and void?
Yes.
This has already been cancelled on 14/12/98.
By cancellation deed, that cancellation deed has been held to be.
Did you challenge the deed of cancellation or did you challenge
No,
the...
I have not challenged. They have filed this original suit
Okay.
for declaration that the deed which by which I had purchased land was null and void.
And you did not file a suit that this cancellation deed is bad.
No, I did.
So this suit cancelled by cancellation deed
the-
dated
the-
14/12/98.
The lower court held, the appellate court held, actually, that this cannot be the way of cancellation of the deed. The proper way is that declaration has to be there from the court. So, both the original court, the lower court, as well as the appellate court, has held that the land was of the plaintiff's because of partition and because of the compromise decree, and so I am not entitled. So the sale deed dated 7/12/1998 is null and void.
What is the date of registration of this?
Registration in 1999, they have filed this suit.
Registration of the same deed. This is the deed.
हाँ, तो वही
When was it registered?
7/12/99.
Same day.
Yes. So 7/12/1998 is the date of registration of the sale deed. 11/12/1998, after 4 days, they filed compromise petition that my submission is they cannot do this. This Tahnu Rautia cannot do this because if he does this, this becomes a collusive suit.
Who has exhibited the original deed?
Tahnu Rautia.
That is you.
नहीं, हम तो appellant, हम सूरजनाथ
जब
साहू.
आपको 7/12/98 को आपको डीड हो गया, तो डीड आपके पास होना चाहिए था.
हाँ.
Who has exhibited? 7/12/98 का डीड किसने एग्जिबिट किया है?
Deed is not in dispute. No, deed.
डिस्प्यूट की बात नहीं है, आप परचेजर है, ये डीड आप देखिए, एग्जीक्यूट होने से लेकर काफ़ी कहानियाँ होती हैं। कभी होता है कि एग्जीक्यूट करा देते हैं, जब कंसिडरेशन मिल जाएगा तो दे देंगे, कभी होता है कि पोजेशन के साथ दे देंगे, बहुत तरह के चीज़ें होती हैं। इसीलिए हम जानना चाहते हैं कि इसको एग्जीक्यूट किसने करा।
कुछ फैक्ट्स और हैं जो हम बता रहे
है इसमें ये सब कहानी है।
हैं। कुछ फैक्ट हम बता दे रहे हैं।
Important facts are required to be brought in the law. हम उसको laws permit them only.
अभी इनको बताने आप तो परेशान हैं, बताइए।
कुछ फैक्ट और है कि ये बोले कि जो 14/12/1998 को जो कैंसिलेशन डीड जो एग्जीक्यूट करते हैं और 11/12/1998 को जो कंप्रोमाइज पिटीशन फाइल करते हैं, so they have given the reason that without paying any consideration amount, this deed has been executed because the person that Tahnu Rautia was a laborer, and Lord, I have misled. Lord Tahnu Rautia has appeared in this case, Lord. In the
What is there any concurrent finding regarding consideration?
Lord Tahnu Rautia has stated.
Finding बताइए।
नहीं, finding उस पर हुआ ही नहीं है. That was not the
Find-
question of law. That was not the.
He said that there was no consideration to this.
नहीं, he said, look, ये बोले प्रसाद रौतिया and his the brother of Tahnu Rautia, Mahnu Rautia. They said like this. Tahnu Rautia appeared. Tahnu said that yes, I have sold the landlord and I stand by it, Lord. He said that on blank papers his thumb impression was taken to file compromise petition as well as the deed of cancellation. So he stood by me in this case.
With this part मेरी बात का जवाब नहीं है। Consideration के बारे में क्या finding है? Because ultimately the suit was filed for cancellation of sale deed dated 7/12/98.
Yes.
So we are concerned with this particular
Consideration
document.
amount पे कोई finding.
What was the ground for cancellation?
Ground था कि during pendency of the case, Lord, this land was sold, so this will be governed by Section 52 of the Transfer of Property Act. And because the finding is that the land was of plaintiff's lot, so this becomes null and void.
Transfer Property Act Section 52. आपका क्या आंसर है?
There are two things very
Who are
important.
you?
I am responding.
अरे अभी कहाँ अभी आप बहुत दूर हैं। अभी आप थोड़ा दूर
जब
रहिए।
कोर्ट ऑफ पार्टीशन सूट हो
देखिए,
चुका है,
ऐसा गलत-
उसके बाद कैंसिलेशन डीड फाइल हुआ।
गलती मत
पार्टीशन
करिए
सूट वाज
ऐसा।
ऑलरेडी कंसीडर्ड एंड अलाउड एट फ्रॉम माइनर दैट पर डीड इज कंसर्न दैट इज नल एंड वॉइड।
52 का इसमें इसलिए नहीं है क्योंकि ये दिस पेंडेंट से कवर्ड नहीं है। When the suit is for partition, everybody is a co-owner of the property.
हाँ, लेकिन
Undivided portion of suit property can also be sold.
but
इसलिए 52 का तो कोई स्कोप नहीं होना चाहिए।
52 को ही रिलाई करके ये जजमेंट है।
कहाँ है दिखाइए।
Yes. 52 has been quoted in the appellate decision. Page number 32 of the memo of the internal page.
आप पैरा नंबर 33 में आइए। पैरा नंबर 33 of the appellate court's judgment.
Yes. Yes. May I?
हाँ
Therefore, on the basis of the appellate judgment.
हाँ
Therefore, on the basis of our discussion, it stands proved beyond doubt that there was very much a partition of the suit land among others between Bandhu Rautia and Pillu Rautia, and the suit land was under share of original plaintiffs Mandeep Rautia, son of Pillu Rautia, whereas defendant number 2 had no right, title or interest therein. Therefore, the impudent transfer of land of 0.05 acres by defendant number 2 Tahnu Rautia in favor of defendant number 1 by sale deed number such and such dated 7/12.
तो अब जो ये जो वेरी मच ऑफ पार्टीशन की बात कर रहे हैं, व्हाट इज द डेट ऑफ पार्टीशन?
The date of partition, they say that it was much before survey.
जो भी है ये फाइंडिंग है ना, that he did not have the title to transfer.
Look, this
क्या कौन सा कहानी सुना रहे हैं आप?
this finding has been compromised in the appeal.
Compromise means
अपील में compromise के basis पे disposal हो गया. Look, that
कोई
finding.
मतलब नहीं. There was already on the day you sold the property. The property was sold to you. That is on 7/12/1998. उस दिन compromise exist नहीं कर रहा. उस दिन उसको title नहीं. बात खत्म. जिस दिन ट्रांसफर हुआ उस दिन टाइटल होना चाहिए.
But the case was pending, Lord. But the case was pending.
केस से
It
क्या?
would have-
इससे कोई मतलब नहीं.
Lord, Lord, by my submission.
You did not have a title on that.
Lord, may I submit?
अब आप
Lord,
submission
on that date, appeal was pending. The decision of appeal might have come in my favor or in favor of the other side, Lord. Lord, but just after selling the land in my favor, Lord, just after 4 days, Lord, they have compromised the suit, Lord. And Lord, my submission is, Lord, this compromise, Lord, is like a collusive suit.
देखिए आपको एक चीज बता दे रहे हैं. अगर मान लीजिए ऑलरेडी पार्टीशन था, इस पर्टिकुलर केस में इशू बना था as to whether there was a partition or not.
Lord,
इशू बना था कि नहीं बना?
Lord, issue बना था.
बना.
अब उनका
Therefore, अगर वो मेरिट पे डिसाइड होता तो यही होता कि ऑलरेडी पार्टीशन था. मेरिट में तो आपके अगेंस्ट में ही डिसाइड.
अब अगर प्लांटिव्स का
उस
डिपोजिशन
कॉम्प्रोमाइज के कारण आपको कोई लिबर्टी और कोई एडिशनल लिबर्टी नहीं.
नॉट प्लांटिव्स का अगर डिपोजिशन हम लोग देखते हैं
नहीं,
तो
नहीं.
ही सेज
Second appeal में
that
नहीं
there was
देखते.
only a partial partition, Lord. He himself said there was only a partition.
वो नहीं देखेंगे.
Look, इनका स्टेटमेंट देखा जाए, he says at one time, Lord, he says there was partition. At that time, Lord, he says that there was only partial partition. This has been recorded also. And Lord, this becomes a collusive decree, Lord, because after selling land in my favor, Lord, just after 4 days, Lord, he files a compromise petition. Lord, the purpose would be to oust me from the land. And Lord, this has been exempted in section 52, Lord, of transport.
There is a concurrent finding that there was already a partition.
But it was partial partition, Lord. He himself says this. And Lord, concurrent finding तो आ ही नहीं रहा है. Concurrent finding Lord नहीं आ रहा है because in title appeal was pending and it was compromised. Lord, the issue of partition is not.
वो जो कॉम्प्रोमाइज हुआ था वो कोई और ही केस था ना. इस
Yes,
केस में तो कॉम्प्रोमाइज नहीं हुआ था.
हाँ, दूसरा
That
केस
was
था.
another case.
Yes,
Prior to that, there
that was
a partition.
compromised. That was compromised and there is no adjudication in that case. Lord, and the compromise was that nobody would sell that land. And Lord, before this compromise was arrived, Lord, a particular portion of the land was sold to me, Lord. And Lord, they have also sold. But this has also come. The plaintiffs had also sold the land, Lord, some part of land, Lord. And my vendor has also sold, Lord. So both the parties were selling, Lord, and this has been challenged. And Lord, section 52, Lord, the lower court has relied upon, Lord. It has come in, Lord, page 15, page 32.
Page number?
Internal page 15 of the judgment.
Which judgment?
Lord, appellate court.
15.
Yes. Last paragraph. Section very. It has been quoted in section 52, transfer of property, pending suit relating thereto. during the pendency in any court having authority within the limits of India, excluding the state of Jammu and Kashmir or established beyond such limits by central government, of any suit or proceeding which is not collusive and in which any right to movable property is directly and specifically in question. The property cannot be transferred or otherwise dealt with by any party to the suit or proceeding so as to affect the rights of any other party thereto under any decree or order which may be made therein except under the authority of the court and on such terms as it may be imposed. My submission is not this type of cases were exempted in this section. But the person is selling land in my favor and thereafter he is compromising the case and the case drops. So the partition, there is no adjudication on partition law. And Lord, in this case, Lord, the plaintiff himself says that there was only partial partition. So if there is partial partition, Lord, can that partition be reliable?
Permission, I just say one thing. There is partition, my lord, between the parties taking place first 893 and thereafter it was rolled. In that partition, adjudication was made. I have an order of that judgment of it was rolled by.
Or the learned counsel appearing on behalf of the appellant.
And Lord, one more thing, Lord, just one line. Lord, the plaintiff, Lord, in their plaint, Lord, they have claimed that possession is with them. They were in possession, Lord. And Lord, thereafter they have filed execution case for recovery of possession. So one side, Lord, they say they have claimed possession over the land and thereafter they are.
Essay number 191 of 2017. For Mr. Ravi Kumar, learned counsel appearing on behalf
Ravi
of
Kumar
the
Singh.
Ravi Kumar Singh, the learned counsel appearing on behalf of the appellant. This appeal has been filed against judgment dated 18th of August 2016, decree drawn up on 9/9/2016, passed in title appeal number 22 of 2009 by learned District Judge Roman 6 Kumla, whereby the title appeal has been dismissed. The trial court judgment is dated 26/2009, decree is dated 4/7/2009, in title suit number 12 of 1999, passed by learned Vincent Kumla, whereby the suit was decreed. And the registered sale deed dated 7/12/1998 was declared to be illegal inoperative. And the defendant number 1 was directed to hand over the possession of the suit land to the plaintiffs. The learned counsel for the appellant has submitted that during the pendency of partition suit, the eldest son of the family sold 5 decimal of land to the defendant by registered sale deed dated 7/12/1998. At that point of time, the appeal arising out of the partition suit was pending. The partition suit was numbered as, sorry?
32 of 90.
32 of 94.
नहीं नहीं वो अपील
Partition appeal.
Partition suit was
8
8 of 93.
Thereafter partition.
8 of 93, and the corresponding appeal was title appeal number 32 of 94. The suit was dismissed. The partition
Yes.
suit was dismissed. He submits that after the sale of the property, there was a compromise in the partition suit dated 11/12/1998, and as per the compromise, each of the co-sharers of the property were to, each of the parties to the property, to the suit, were to remain in possession of their respective portion, and they were not to sell it to anybody else. As a sequel to the compromise, the plaintiff had unilaterally executed a deed of cancellation dated 14/12/1998. However, having realized that unilateral cancellation of sale deed is not permissible in law, he had filed the present suit for cancellation of the sale deed dated 7/12/1998.
टहनू इज नॉट प्लांटिव. टहनू जो हमको बेचा था वो प्लांटिव नहीं, वो दूसरा साइड है. जो पार्टीशन में 2 साइड जो था, दूसरा साइड जो ये केस किया. टहनू हैज नॉट फाइल्ड दिस.
आपका वेंडर कौन है?
मेरा वेंडर है टहनू रॉकिया.
The vendor of the appellant is
टहनू रॉकिया. रेस्पोंडेंट नंबर 4
respondent number
4 और
Four.
डिफेंडेंट नंबर, he was defendant number 2 in.
who was defendant number 2 in the suit.
Yes.
Defendant number
Yes. डिफेंडेंट नंबर 1 हम थे और डिफेंडेंट नंबर 2 टहनू रॉकिया.
who was defendant number 2 in the suit, and the present appellant, namely Surajnath Sahu, who is the purchaser of the property covered by sale deed dated 7/12/1998, was the defendant number 1 in the suit. The suit was filed by Prasad Rautia and Prasad Rautia, son of Mahabir Rautia,
Manbir.
and Manbir Rautia, and Lakshmi Kumari, daughter of late Manbir
Yes.
Rautia. The Learned Counsel has submitted that after having executed the sale deed dated 7/12/1998, the parties in the title partition, in the title appeal number 32 of 1994 had entered into compromise, and by that time the right, title and interest with respect to 5 decimal of land was already transferred in favor of the appellant, and therefore the learned courts were not justified in cancelling the registered sale deed dated 7/12/1998 and declaring the same as null and void and inoperative in rights of law. The Learned Counsel has also relied upon Section 52 of the Transfer of Property Act and has submitted that the case would be governed by the principle of less pendants, and therefore the sale deed executed on 7/12/1998 during the pendency of title appeal number 32 of 1994 was legal and valid. यही आपका केस.
मेरा कहना है कि 52 का exemption में ये केस आता है because this compromise was a collusive act.
Okay, the learned council has submitted that the principle of lis pendens will not apply. Okay, ठीक से लिखेंगे ना, the principle of lis pendens will not apply as the compromise was collusive between the parties to the partition suit number 8 of 93 slash title appeal number 32 of 93. तो डिक्री ड्रॉ हुआ होगा ना
Yes.
उसको आपने चैलेंज किया है क्या?
नहीं, हमने चला. I was
During the
not
course
party.
of argument upon a query of this court, the learned counsel has submitted that the compromise decree which was passed in the title appeal number 32 of 1994 has not been specifically challenged by the appellant. After hearing the learned counsel for the appellant and having gone through the impugned judgment passed by both the courts, this court finds that it is not in dispute that the partition suit number 8 of 93 was dismissed and appeal arising out of the same was pending in title appeal number 32 of 93. This court finds that both the courts have recorded finding that there was already a partition amongst the family members prior to 7/12/1998. There was already a previous partition amongst the family members, and the learned appellate court has categorically recorded a finding that
There is no finding of the appellate court in that case.
has recorded that there was a partition of the suit land amongst others between Bandhu Rotia and Hindu Rotia, and the suit land was under the share of original plaintiffs, namely Mahavir Rotia, son of Manvir Rotia, son of Pilua Rotia, and the defendant number 2 had no right, title or interest therein. The learned appellate court has also recorded that the impugned transfer of land of area 0.05 acres by defendant number 2, the Hanvi Rotia, in favor of defendant number 1, while Sailgi number 2672/98 dated 7/12/1998 was illegal and void. This court finds that the learned courts have given concurrent findings that the vendor of the appellant did not have the right, title and interest over the property which was sold to the appellant, who was defendant number 1 in the suit. In view, the law is well settled that a vendor cannot transfer better title than what he possesses. And in view of the aforesaid concurrent findings recorded by the court, this court finds no substantial question of law involved in this case, which is hereby dismissed.
चलो एक चीज है, जो कंप्रोमाइज पिटीशन जो फाइल हुआ था उसके हिसाब से टर्नू हुआ
कॉम्प्रोमाइज डिक्री के लिए अलग से सूट फाइल कल्यूसिव होगा। ऐसा नहीं होता है कि किसी भी प्रोसीडिंग में आप कॉम्प्रोमाइज डिक्री को
मतलब हम एक चीज कर रहे हैं कि compromise decree के हिसाब से तन्नू राउतिया was to be in possession of that land, जिसको हमको बेच दिए, तो उसके हिसाब से मतलब एग्जीक्यूशन होना चाहिए तो उनके साइड से.
Item 8, second appeal 129 of 2022.
Against reversal matter. Case was for eviction. Issue of maintainability was raised matter. Sought fact if matter will kindly take note. So 18th August.
You are the landlord or the tenant?
I am the tenant. I was the defendant, appellant, defendant, respondent.
इसको ले लीजिए सर.
I am the defendant, respondent, appellant. I
Tenant.
was the tenant, and 2-3 dates will be relevant for the purpose.
The suit was dismissed.
Suit was dismissed.
Appeal allowed.
Appeal. Well,
What was the reason for dismissal?
suit was dismissed on maintainability. It was not maintainable. And my lord, 2-3 dates, if my lord will kindly take note of, because that will be the basis of my argument. 18th September 1962.
18/9/1962.
So my father was inducted as a tenant by the plaintiff. Now, 27th of January 1989,
Yes, 1989.
a sale deed was executed, registered sale deed was executed by the plaintiff in favor of the defendant for a valid consideration of 40,000. The sale deed
Just
contemplated
a moment. Registered sale deed
registered sale deed.
with respect to the same property.
Same property. In favor of defendant's father, my father.
Independence father. Okay. And you were already in possession.
Yes, I, as a tenant till that point of time I came. Then it was, there will be one relevant I should submit that there was a condition stipulated in that registered sale deed that if the plaintiff got the payment till 31st/1/1990, if he makes a repayment, the property will be reconveyed back to him. And that exercise was
Just a
also.
moment.
Yes.
There was a condition that if the plaintiff repaid the amount by, it was a kind of
Conditional
a
sale.
conditional sale.
Conditions. Yes, conditions. That sale deed speaks about it.
Conditional sale, right?
Yes.
If the condition was to be satisfied by 31/1/1990.
90, then it will be reconveyed, and that was
Basically वो borrow
satisfied.
किया होगा, ऐसा borrow किया होगा तो whatever.
No, what it
Must be having some problem.
Maybe. And that was reconveyed also.
Reconveyed also.
Also, yes. The condition
The
was.
property was reconveyed
Yes.
when?
It was reconveyed on 29th January 1990.
Reconveyed. Yes.
Now we raised issue, madam, that under Building Act, after execution of sale deed, my dual relationship of landlord-tenant does not survive, and if at all remedy was there, it was under transfer of property to get me evicted. Now trial court, considering this fact, has held
Just a moment. So your dual relationship severed from 27/1/1989.
89.
Did you pay any rent?
No, nothing else.
After 28/1/1989, did you pay any rent?
Nothing is on record, and that is precisely our case, and that was considered by the court. That nothing has survived thereafter, and he remained silent, and suit is of 2006. Title eviction suit number 5 of 2006. One nominated
Where is the deed?
deed is exhibited. Yes.
Exhibit number?
SCR has not been, but I am just guessing.
Exhibit number?
Give the number, madam.
Exhibit number.
A. E.
Did he disclose, the plaintiff, he disclosed about the deed? Must have.
So it is marked from our side exhibit A. He did not disclose. He set up the suit based on this fact. Now, when appellate court has taken note of it, why there is a reversal?
Deed of reconveyance was marked as exhibit 4. How do you say he did not?
Reconveyance, my lord, when we read it.
When there is a conveyance, then only there is a deed of
Reconveyance, yes, yes. I said of deed, I said, not exhibit A.
reconveyance was marked exhibit 4.
My lord, we are having that. Yes. Yes. yes.
Where is the
I said-
deed of, show me the deed of reconveyance.
Yes, reconveyance is there, my lord, right for. My lord, will it's reconveyance. I had only one time to talk to my lord, so
No, no problem.
the second page, my lord, you find कोई हक दावा नहीं है. That was bottom.
What is the substantial question of law?
My question number 5, 6 and 7 can be clubbed together.
ऐसा आपने
नहीं तीनों चुके.
मतलब 10 को substantial question of law
10 नहीं.
20 को पढ़ के बताएंगे.
If one judgment, if my lord will see Supreme Court, so my lord so desires. This is, and I read just for a moment, my lord. There was an agreement of sale. Thereafter, dual relationship of landlord-tenant only, my lord. Para 8, if my lord.
It is not a case of cancellation of deed.
No,
It
it's
is a case of reconveyance.
reconveyance.
So what would be the status of the tenant after reconveyance? That is the question.
That is the question.
For the
Grateful.
learned counsel for the appellant. The learned counsel for the appellant has submitted that the appellant was the alleged tenant on the suit property, and suit was filed under BBC Act. Jharkhand Building
Jharkhand
Control
Building
Act.
Control Act. 2000.
2000. He has submitted that the father of the appellant was inducted by plaintiff as a tenant as back as on 18/9/1962. However, a registered deed by way of conditional sale was executed on 27/1/1989 by the landlord in favor of the plaintiff's father.
Defendants. Appellate's father.
in favor of the appellant's father, indicating that if the amount mentioned therein is not repaid by 31/1/1990, is repaid by 31/1/1990, the property will be reconveyed in favor of the landlord. Tenant. He submits that a deed of reconveyance was executed on 29/1/1999. 1998, the Learned Council has
90,
submitted
my lady, 90.
29/1/1990. Okay, 29/1/1990. The Learned Council has submitted that there is no evidence. Did you pay rent after
No, nothing.
1989?
Nothing. My lord will find exhibit, if my lord will see the exhibit document.
एक second.
Exhibit 2 by A is of 84. 84, 2 by B is again of that same period.
Okay, आपका submission लिखाते हैं.
Yes.
However, the Learned Council for the appellant has submitted that after the registered deed dated 27/1/1989, the appellant or his father did not pay rent,
Nor it was demanded by them.
nor it was demanded by the plaintiff. He submits that after the deed of reconveyance dated 29/1/1990, the relationship of landlord and tenant did not resume.
Yes.
Correct.
Yes.
He submits that under such circumstances, the remedy under the BBC Act was not available, and therefore the suit was rightly dismissed as not maintainable. But this aspect of the matter was not properly considered by the learned First Appellate Court while reversing the judgment. The Learned Council submits that substantial question of law be framed as to whether the relationship of landlord and tenant resumed after the execution of deed of conveyance.
After execution of sale and after reconveyance, both.
Only
Because that is one is segregating the relationship.
after execution of the
Sale deed or
deed dated 27/1/1989, which was followed by reconveyance deed dated 29/1/1990,
Wait.
and consequently whether the suit itself was maintainable under the JBC.
JBC.
Considering the aforesaid submissions and having gone through the impugned judgments, the same question of law is
Yes.
framed. This appeal will be heard on the aforesaid substantive question of law and issue notice to the
Respondents to you.
respondents under ordinary process for which requisite be filed within by 9th
Yes, it can.
by 9th of May. It is further observed that the appellant would also file envelope under registered cover and deposit it in the registry so that the notices be sent to the concerned court for service. The notices be sent by registered post to the concerned court for service through ordinary process.
Grateful. It is under order 323 that exercise is being taken to expedite. On that judgment, I have given para 8.
The Learned Council has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2000, bracket 9 SEC 339, para number
8. It is dealing well. There was agreement of sale.
8.
So the jural relationship came to an end. That is what is affirmed.
पैरा नंबर 8 कब करिएगा बताइए अब तो
जब
सूर्य
इंडियन
पूरा
का हम तो छोटा ही
respondent
क्वेश्चन है
होते
हम तो
अब सुन लिए, अब क्या ही बचा है इसमें?
Maintainability में we are not going to the roving inquiry of fact.
Pose this case on 10th of July for final disposal in the supplementary cause list that the records be called for from the concerned court with this order be communicated to us. अभी आया ना सुप्रीम कोर्ट का जजमेंट, एक्सपीडाइट करना है लैंडलॉर्ड टेनेंट।
हाँ, होना ही चाहिए मतलब when we come here from other side we feel the brand, so both way around even extinction cases are not picking up because of 6 month direction, so second appeal first appeal hearing will be expedited
For hearing,
मेरा एक ही सोच है, लोगों के मरने के पहले अगर सर्विस कंप्लीट हो गया है तो डिसाइड कर देना, क्योंकि मरने के बाद तो there is no future.
Substitution is the first appeal's best component. Great.
for hearing item 9, second appeal 328 of 2016.
बताइए।
Your Lordship appeared on behalf of appellant. My senior has to argue his case,
Rejected.
but due to his bad health, he went to the doctor.
आपकी हेल्थ ठीक है?
So,
आपकी हेल्थ ठीक है कि नहीं है? बताइए।
your Lordship, I'm a newcomer.
न्यू कवर
This is
मतलब?
my- this is
न्यू
my-
कवर में तो आप ज़्यादा पढ़ के आए हैं आपके सीनियर से।
This is my second.
कौन से
day.
कॉलेज से पढ़े हैं जहाँ पढ़ाई नहीं कराता?
From Choटा Nagpur Law College.
वहाँ नहीं पढ़ाई
I
कराता?
just I received
छोटा
this
नागपुर
file.
लॉ कॉलेज में सेकेंड अपील का स्कोप पढ़ाई नहीं कराते?
होता है।
क्वेश्चन ऑफ लॉ पढ़िए, ऐसे नहीं हम टाइम देते हैं।
Your Lordship, I just received this file, so I will go through it.
भाग्य मनाइए कि हम आपको बहस करने बोल रहे हैं और आप इसको अवेल नहीं करना चाहते।
Substantial question of law, whether the learned court of property below 5 affirming the findings of the trial court to exercise its jurisdiction within the
ये नहीं, आप गलत पढ़ रहे हैं। सब्सटेंशियल क्वेश्चन ऑफ लॉ ऑर्डर डेटेड 27/9/2023 से पढ़ना होगा। कहाँ है ऑर्डर? उसके लिए तो आपको
I just received this file, so I
कौन सीनियर है आपको डांट सुनने के लिए आप भेज दिए?
संजय कुमार तिवारी।
कोर्ट नहीं आए?
No, Your Lordship.
कहीं कोर्ट में अपीयर होंगे तो आपको कंटेंट प्रोसीडिंग में प्रॉब्लम होगा।
Due to his bad health, he went to the doctor.
When?
Around 2:30.
कोर्ट आके चले गए ना, ऐसा किसी कोर्ट में दिखेगा क्या? भेजे किसी को?
He is not.
भेजे?
He is not present.
भेजे? पता करके आपको फोन नंबर बताइए। कब करना है बताइए।
Kindly put this matter after vacation.
आपका कौन सा वेकेशन?
After summer vacation.
आप हारे हैं कि जीते हैं? ट्रायल कोर्ट में? ट्रायल कोर्ट में आप हारे थे कि जीते थे? नहीं पता।
Trial court में
सेकेंड अपील नंबर 328 of 2016। नाम बताइए अपना।
अंकेश कुमार तिवारी।
सॉरी
Ankesh Kumar Tiwari.
Ankesh Kumar Tiwari, advocate, submits that the appeal counsel, Mr. Sanjay Kumar Tiwari, has left the court as he was not present. He seeks adjournment. Nobody appears on behalf of the respondents. It could date with the final disposal. Hold this case for final disposal on next case forward.
Item 10, second appeal 350 of 2016.
हाँ बताइए.
This appeal has been admitted in terms of order dated 9/11/2017.
हाँ बताइए. ठीक है.
The plaintiff has filed a suit on
रिकॉर्ड
the
रिकॉर्ड देखते हैं. हाँ बताइए. शेड्यूल ऑफ प्रॉपर्टी क्या?
plate para 5. Oh, sorry, plate para 11.
पैरा 11. हाँ बताइए.
Yes, sir. Make it help where my plate.
हाँ हाँ.
थोड़ा नहीं था
But
Okay.
That the court be pleased to hold and declare by a decree passed in favor of the plaintiffs and against the defendants that the plaintiffs are owners, title holders, and possessors of the suit land, fully described in Schedule A below, and that the defendants were allowed to keep their cattle and to construct cattle sheds on the part of the suit land fully described in Schedule B below, temporarily and not vacating the suit lands, and by the not removing the cattle and the cattle sheds from the suit land, the possession of the defendants over the suit lands have become that of trespassers, and the same is illegal and unauthorized now. B. That on such adjudication, a decree be passed in favor of the plaintiffs and against the defendants for the eviction of the defendants from the suit land fully described in Schedule B below, and the defendants be directed to remove their cattle and cattle sheds from the suit lands within a time to be fixed by the court, failing which the cattle and the cattle sheds lying on Schedule B below be removed, vacated from the suit land described in Schedule B below, and the possession of the vacant land be given to the plaintiff by machinery of the court. C.
Thereafter, with cost and other areas.
that's right.
Can we turn next page
The
where
schedule. The schedule.
the sketch map has been given of Schedule A land, of Schedule B land. Schedule A land has been defined. Schedule A.
Schedule A. In district of Sahibganj, division Sahibganj, PA Sahibganj, and lands of Mauza, Sobhapur, Ganga Prasad, bearing JB number 525 of 938, measuring 1.
I read the schedule. Now there is a sketch map also.
The sketch map is Schedule B.
Yes. तो sketch map is there अलग से पीछे
Now
एक
the
तो
yes.
map बना हुआ.
Now let the specific case was the plaintiff was that Schedule A land was occupied by
defendant number 1 to 3, and schedule B land was occupied by defendant number 7. Which your lordship will get. Para 5 of the plan.
Para 5 of the page.
That after the rainy season was over, the plaintiffs requested in the year
Just
2000.
a minute. Para 4 also make kindly.
Para 4, that the defendants who have greedy eye over the suit lands of the plaintiff came to the land in month of August 2005 during rainy season and kept their cattle on the land to save their cattle from the flood and rains with verbal permission of the plaintiffs, and the defendants started keeping their cattle on the portion of the suit land described fully in Schedule B, given at the foot of the plain for temporary period for a few months only, and that the defendants have also cattle shed constructed by them temporarily for protection from rains, and that the defendants keep their cattle on the suit land fully described in Schedule B below and also shown in sketch map attached at the bottom of the Schedule B. That
After rainy season flood, the defendant did not vacate the land in spite of the EK request.
So how do you say that Schedule B was in possession of defendant number 7 only?
Oh yes.
तो वैसा हो गया जैसे कि
Just,
कोई
just a minute. It has been given, it is reading itself.
न तो रिलीफ से ऐसा लग रहा है ना ही तो रीडिंग से ऐसा लग रहा
ठीक है, अजय भी मिनट 2-3 ये पढ़ने से थोड़ा गड़बड़ है। Anyway, मिनट the
है।
schedule
क्वेश्चन ऑफ लॉ में
A,
आए सीधा क्वेश्चन ऑफ लॉ में आते हैं यू से दैट द सूट लैंड इज बिग
yeah, मिनट he has given the area of his land in his possession. एक कट्ठा 3 एक 3 ऊपर पारा 1 में देखा जाएगा।
शेड्यूल इज
The land which is in
2-6
occupation of the plaintiff has been given. एक कट्ठा 3 डिसमिल 2 धूर। पारा 1 का पेज 2।
एक कट्ठा 3 डिसमिल 2
दो। Now he has not given any area of Schedule A and B land. Schedule A and B land are in 2 parts.
शेड्यूल है तो 2 कट्ठा 6 दूर
Now kindly see the sketch map itself again. स्केच मैप में शेड्यूल ए लैंड का पूरा दिया। शेड्यूल ए लैंड 2 कट्ठा 6 डिसमिल 4 धूर।
शेड्यूल बी देखिए
यानी कि उनका एरिया ये ऑक्यूपेशन में नहीं था, जबकि वो अपने स्पेसिफिक लिख रहे हैं पारा 1 में 1 कट्ठा 3 डिसमिल 2 धूर।
शेड्यूल ए में लेकिन 2 कट्ठा 6 डिसमिल 4 दूर।
हाँ, तो इसका मतलब शेड्यूल ए का एरिया जो है इट इज नॉट टैलिंग विद द एरिया क्लेम्ड बाय द प्लेंटिफ।
देखिए शेड्यूल ए का डिस्क्रिप्शन जो है उसमें पढ़िए इन द डिस्ट्रिक्ट ऑफ साहिबगंज डिवीजन पढ़िए
Yes.
In the district of Sahibganj division, Sahibganj, PA Sahibganj, lands of Mauza Sobhapur, Ganga Prasad bearing JB number 525 of 938 measuring 1 kattha 3 decimal 2 dot, and the land of JB number 525 oblique 939 measuring 1 kattha 3 decimal 2 dot, total 2 kattha 6 decimal and 4 dot, bounded by North Loknath Yadav and others.
दोनों का मिला के 2 कट्ठा 6 डेसिमल एंड 4.
My submission is that after having seen the para 1 of the plaintiff itself, the plaintiff is claiming दो JB नंबर में 1 कट्ठा 3 डेसिमल 2 दूर, 1 कट्ठा 3 डेसिमल 2 दूर, इन टोटल 2 कट्ठा 6 डेसिमल 4 दूर. Now, what is the area of schedule of this B land, which is in occupation of the defendant? 1 कट्ठा 1 कट्ठा 1 कट्ठा 15 कट्ठा, ये क्या 15 कट्ठा B land? ये 15 कट्ठा कहाँ से आ गया?
इसमें शेड्यूल बी कहाँ मार्क किया हुआ है?
वो शेड्यूल बी इसी स्केच मैप में मार्क किया हुआ है,
राइट हैंड साइड में.
राइट हैंड साइड में टॉप में.
बी लैंड, और यहाँ पे भी बी लैंड लिखा है.
यहाँ भी बी लैंड
1 कट्ठा 15 डेसिमल. इधर बी लैंड है, इधर भी बी लैंड है, मतलब बी लैंड इज इन 2 पार्ट्स, राइट. 1 कट्ठा 15 डेसिमल. एक कट्ठा 15 डिसमिल कितना हुआ?
दोनों अलग अलग जो जोड़ दो, एक कट्ठा में कितना?
एक कट्ठा में कितना डिसमिल?
नहीं, हर एक एरिया का डिफरेंट है. बोल रहे गवर्नर को बताना है कि हर एक एरिया में डिफरेंट होता है कट्ठा.
और इसमें इन्होंने लिखा है 16 कट्ठा.
16 कट्ठा.
पंद्रह कट्ठा और 1 कट्ठा हो तो गया 16 कट्ठा. शेड्यूल बी लैंड 15 कट्ठा और 1 कट्ठा, इनका शेड्यूल बी में डिस्क्रिप्शन है 16 कट्ठा.
1 कट्ठा है शेड्यूल बी लैंड का दाहिने
दो
तरफ
पार्ट
वाला
है.
पार्ट.
शेड्यूल बी में वो जो 2 चौक बना हुआ है ना बीच में, एक का 15 कट्ठा लिखा हुआ है और उसके बाद राइट हैंड
यानी कि
साइड
हम पूरा को पाई कर लिए 16 कट्ठा, यही हो करने का
16 कट्ठा आउट ऑफ 2 एकड़ 6 कट्ठा 4 धूर.
एकड़ कट्ठा दोनों में बीघा
एकड़ नहीं 2
बीघा
सॉरी 2 एकड़ 6 डिसमिल 4 धूर.
नहीं, उसमें उसको बीघा पढ़ा जाए
तो
तो
इसको क्या पढ़े? 2
बीघा.
6 4 को क्या पढ़े?
हाँ, 6 डिसमिल 4
2 बीघा 6 डिसमिल
6 कट्ठा
6 कट्ठा.
अच्छा.
ठीक है, तो वो तो उसका पार्ट है ही, क्या दिक्कत?
पार्ट है तो असरटेन करके हमको बताया जाए कि कितना एरिया में. पहली बात. दूसरी बात कि खुद कहता है प्लेंटिव कि रॉकी एंड हिली एरिया, तो उनके पोजीशन में कहाँ से होगा?
नहीं, आप तो दूसरा सबसे
नहीं,
अच्छे
ये
क्वेश्चन ऑफ
इसमें है, सीरीज में है.
तो आप बोलते हैं कि वेग डिस्क्रिप्शन ऑफ प्रॉपर्टी. वेग तो नहीं है, डिस्क्रिप्शन ऑफ प्रॉपर्टी तो है, चौहद्दी भी है. बाउंड्री भी दिया है, वेग नहीं है. बाउंड्री है, चौहद्दी है, मतलब एरिया है. इतना सुंदर सा फोटो बनाया है. बताइए. If the property is identifiable, matter ends. और आपका जो substantial question of law है वो identity पर ही.
उसी पर
तो suit property is very well identified. सर आपको बिना बहस की ऑर्डर मिल रहा है, सही बात नहीं. Heard the learned counsel. आपका appearance भी दिखाते हैं. Heard the learned counsel appearing on behalf of the parties. This appeal has been filed against the judgment and decree dated 28 June 2016, within bracket decree sealed and signed on 27 June 2016, passed by learned Principal District Judge Sahibganj, entitled Appeal number 13 of 2015, whereby the appeal has been dismissed. The trial court judgment is dated 28th of July 2015, decree sealed and signed on 7th of August 2015, passed by learned Senior Civil Judge Roman 2 Sahibganj, entitled suit number 30 of 2007. The learned Senior Counsel for the appellant has referred to the order dated 9/11/2017, by which this appeal was admitted, framing following substantial question of law. The learned counsel for the appellant had submitted that the description of property as claimed by the plaintiff was vague, and therefore the learned courts could not have decreed the suit without ascertaining the total area of Jamabandi number 525 and the areas of Jamabandi number 525/938 and 525/939. The learned counsel has submitted that on account of vagueness in connection with suit property, both the judgments are fit to be set aside. The learned counsel appearing on behalf of the respondents has submitted that the suit property along with its boundary and sketch map was given in the plaint itself, and there was no vagueness in the suit property, and therefore the substantial question of law as framed is fit to be answered in favor of the respondents. The learned counsel has submitted that upon perusal of the plaint itself, it would be apparent that there was no need for measurement of the total area of Jamabandi number 525 and also the areas of Jamabandi number 525/938 and 525/938. After hearing the learned counsels appearing on behalf of the parties, and upon reviewing through the materials on record, this court finds that as per the plaint itself, the plaintiffs are related as per the plaint itself, the plaintiffs claim to be the owner and possessor of the land wherein
वही वही हम कहना चाह रहे थे। शेड्यूल ए का जहाँ डिस्क्रिप्शन दिया हुआ है उसको देख लीजिए। दोनों जमाबंदी जो है 938 और 939 दोनों जो है वही एरिया है। एक कट्ठा 1 बीघा 3 कट्ठा 2 जो टोटल मिला के हो गया 2 कट्ठा 2 बीघा 6 डिसमिल 4 टोटल हो गया। ना इसमें 2 तरह का जमाबंदी है। वो दोनों जमाबंदी का डिस्क्रिप्शन फोटो में कहिए।
ठीक है, फोटो में
नहीं हम बता रहे हैं जो सब्सटेंशियल क्वेश्चन ऑफ लॉ बना उसमें स्पेसिफिक किया हुआ है टोटल
बिना
एरिया
मेजर कि बिना मेजरमेंट के सूट डिक्री हो सकता था, इतना ही।
नहीं टोटल एरिया ऑफ जमाबंदी नंबर 525 and एरिया ऑफ जमाबंदी नंबर 525/938 and 525/939 शेड्यूल ए के मुताबिक जो डिस्क्रिप्शन उसके मुताबिक ये मैप नहीं। इसीलिए ये
इसी शेड्यूल ए में ये 2 एकड़ 6 डिसमिल 4 धुरी और दोनों मिला के यही है।
दोनों मिला के
और शेड्यूल ए का बाउंड्री भी दिया है।
लेकिन कहीं नहीं है कि 939 किधर है 938 किधर है, ये कहना है। एनीवे डिस्क्रिप्शन क्लियर नहीं जो क्लियर है।
The learned counsel for the appellant, उसी ऊपर ही लिखेगा, has also submitted that as per the sketch map, it is not clear as to where is the location of Jamabandi number 525/938 and 525/939. And therefore, the substantial question of law is fit to be answered in favor of the appellant, and judgments and decree passed by both the courts are fit to be satisfied. As per the plaint, the plaintiffs were the owner and possessor of land bearing JB number 525/938 measuring 1/3/2 recorded in the name of Sarju Go and Indradev Go, fathers of the plaintiffs, number 5 and 6, and JB number 525/939 measuring 1/3/2 thirds of Moza Sohanpur Ganga Prasad. समझ ही नहीं आता है। Recorded in the name of plaintiff number 1 to 4, and the same has been described in Schedule A of the plaint. The Schedule A of the plaint is quoted as under. It is further case of the plaintiff that the land was the ancestral land of the plaintiffs and they got their name mutated in the government record. The plaintiffs and the defendants have common ancestors. it was the case of the plaintiff that the defendants had DTIs over the suit land of the plaintiff and came on the land in the month of August 2005 during rainy season and kept their cattle on the land to save the cattle from flood and rain. And they were verbally permitted to do so in the portion of the Schedule A property and described in Schedule B of the plaintiff. The permission was granted only for a few months, and the defendant also constructed shed for protection from rain. The Schedule B of the property is quoted as under. The Schedule B of the property has also a sketch map, and that sketch map has also been quoted by the in the decree passed in the title suit. The sketch map under Schedule A reveals that it is total 2-6-4 tours, Schedule A, within bracket 1-3-2 for twice of 1-3-2 tours, and within Schedule A there are two distinct areas, one consisting of 15 katthas of land and other consisting of 1 kattha of land. Both have been earmarked as Schedule B of the property. Before the learned trial court, the following issues were framed for consideration. Which are quoted as under. कोई वेगनेस ऑफ सूट प्रॉपर्टी का कोई नहीं बना. From the perusal of the trial court's judgment, it is apparent that no issue was framed in connection with vagueness of the suit property, and even from the perusal of written statement filed before the court, there is no plea that the description of the suit property or the area of the suit property is vague. Correct?
Yes.
The trial court, after considering the materials on record, ultimately decreed the suit. So far as the learned first appellate court is concerned, written statement में था कि वेग है. Written statement में वेग है ऐसा बोल के था कि नहीं? This we have to be sure about.
नहीं, वैसे स्पेसिफिक तो नहीं. Defendant का claim है कि it was lying vacant. We came in possession in the year 1972, and thus we acquired, cited by adverse.
Rather, the case of the defendant before the learned court in the written statement was that the land was vacant and they came in possession of the property in the year 1972, and they were claiming adverse possession over the Schedule B property.
Yes.
Correct?
Yes.
Before the learned first appellate court, the argument was advanced that as per the written statement, the cause of action was false and imaginary, and property is unidentifiable, vague, bad for non-joinder of necessary parties, principle of estoppel, waiver and acquiescence and limitation. The learned appellate court, para 3 में है appellate court judgment. The learned appellate court frame the point of consideration in paragraph 9 as follows. The learned appellate court observed that though in the written statement the boundary given by the appellant/defendant are quite different with regard to Schedule A and Schedule B property, but the question for determination before the court was as to whether the plaintiff/respondent is the owner and title holder of the suit land or not. The learned appellate court, after discussing the materials on record, held that the plaintiffs have been able to prove that they are the owners and title holders of the suit land, and the point number 1 was decided in their favor. By deciding point of determination number 2, the learned first appellate court has also considered the pleadings and has discussed the oral and documentary evidences placed on record and recorded a finding that the defendants were allowed to construct their cattle shed over the suit land of Jamabandi number 525 by the plaintiffs and were having permissive possession, and they could not deny the title of the plaintiff over the suit property. This court also finds that the plea of adverse possession with respect to the suit property was also, as raised by the defendants, was also rejected by both the courts. This court finds that the learned court has considered the oral evidence with respect to the boundaries and location of the property and the claim itself had a sketch map which was a part of Schedule B, and the boundaries etc. of the property was duly established by the plaintiff. This court is of the view that once the property stood identified, the description of the property cannot be said to be vague, and merely because there was no measurement with respect to the entire property of with respect to the total area of Jamabandi number 525 and areas of Jamabandi, total area of Jamabandi number 525/938 and 525/939. The same is not fatal to the case of the plaintiff. The Schedule A of the property clearly indicated the total area of Jamabandi number 525/938 and Jamabandi number 525 of 9. Having held as a proceed, this court is of the view that the substantial question of law is hereby answered in favor of against the appellant and in favor of the respondents. This appeal is formally dismissed. Apply appearance witness. Appearance witness.
दे दिए
Orders item 3, second appeal 74 of 2017.
David, I have filed showing the paper publication.
Has been done.
Yes.
So this is upon respondent number
Respondent number 2.
2. Okay. Essay number 74 of 2017. The learned counsel for the appellant, Mr. Ravi Prakash, has submitted that supplementary affidavit has been filed annexing the copy of the paper publication with regard to substituted service of notice upon respondent number 2. Which has been published in Prabhat Khabar,
Yes.
having circulation in Gulnam. In view, he submits that the notice be accepted as validly served. Considering the submission, the notice upon the respondent number 2 is accepted as validly served. Upon button, ये admitted appeal है,
बाकी
admit नहीं हुआ, delay के लिए appeal है, बताइए.
delay है.
How many days? What is the reason for delay? Poor person. Any objection for combination of delay? IA number 1527 of 2017. This petition has been filed for combination of delay of how many days? 35 days in filing this appeal. Counsel appearing on behalf of the respondent number. You are representing respondent number 3 has no serious objection so far as prayer for condemnation of delay is concerned. Considering the averments made in the interlocutory application seeking condemnation of delay, wherein the appellant has stated that the appellant is a very poor person and could not arrange for, is a very poor person and therefore he could not file the appeal in time. Considering the extent of delay of only 37 days, IA is allowed. अब बताइए क्या बोलना है? डिले कर लूँगी, अब क्या करना है?
Let the notice be issued.
किस चीज़ को notice? अब तो substantial question of law पर बहस करिए.
डेट दे दिया. छुट्टी के बाद कोई डेट दे दिया.
छुट्टी के बाद ऐसा नहीं हो कि जिसको सब्स्टिट्यूटेड सर्विस किए वो मर जाए.
वो तो डिपार्टमेंट.
देखिए आपके केस में एक बहुत बड़ा प्रॉब्लम वो ये कि अच्छा अपील नंबर 1 रिस्पॉन्ड नंबर 1 तो एक सब्स्टिट्यूट हुआ है. कौन सब्स्टिट्यूट हुआ है?
उसका
रिस्पॉन्ड नंबर 1 का उनकी तरफ से कौन? Who is appearing for 181? Is anybody appearing? किसी का वकालतनामा है?
लिस्ट में एक नाम आ रहा है.
उनका नाम अपील कर रहे हैं. Have appeared by file वकालतनामा. Let this matter be posted on 11th of June under application. और भी orders हैं?
Item 4, second appeal 254 of 2020.
What is it?
Yes. Two IAs are there. So one is for deletion of appellant from a 6 and second is for a substitution of respondent number 1 revision. IA number 5208 of 2025 for deletion of the deceased appellant number
IA number 5209 of 2020.
8 revision.
Five. पहले डिलीशन है
Yes.
5209 IA number 5209 of 2025 in AC number 254 of 2020 the Learned Council for the appellant has submitted that the interlocutory application has been filed for deleting the name of appellant number 6 who died during the pendency of this case. The death certificate has been placed on record. उनका लीगल ईयर्स ऑलरेडी रिकॉर्ड पर है.
डिलीशन वाले में लड़की वो इशूलेस है, उनका कोई लीगल एयर है नहीं, इसीलिए डिलीशन के लिए प्रयोग किया
The Learned Council had submitted that. Respondent कौन? अभी नोटिस नहीं किया.
गया.
He submits that the applicant number 6 died issueless. And he was predeceased by his wife.
Why?
His wife had predeceased him sometimes
Yes.
in the year 2010. Correct?
Yes.
So who is filing this?
Since he is appellant himself, so on behalf of appellants are filing this.
Other applicants.
The other appellants. They are relatives.
Considering the aforesaid submissions, IA number 5209 seeking deletion of appellant number 3 is hereby allowed. Counsel for the appellant is directed to carry out necessary correction in the cost item in ready within a period of 1 week. Yeah, by 11th of June. और बताइए क्या है सब्स्टिट्यूशन ऑफ?
एक सब्स्टिट्यूशन है रिसीवर रिस्पोंडेंट नंबर का 1 का है. लेट्स प्लीज 11 जून तक
आप कर देंगे ना, क्योंकि ऑर्डर आते हैं कभी 1-2 दिन लेट हो जाए. 11 जून तक आप उसको डिलीट कर देंगे. इसमें क्या करना है?
सब्स्टिट्यूशन है. इसमें क्या था रजित कि इसके लिए जब ये सेकंड अपील बीएफडी हुआ था तो सीएमपी फाइल किया गया. तो ड्यूरिंग द पेंडेंसी ऑफ दैट सीएमपी शी डाइड एंड
सीएमपी का क्या हुआ?
तो एलाउ हो गया जी. और उनका जो लीगल एयर्स थे वो सब रिकॉर्ड पे आ गए. दैट वाज फाइल्ड विदिन टाइम.
IA number 5208 of 2025. The Learned Counsel for the appellant has submitted that respondent number 1, namely Chandrika Devi, has expired during the pendency of CMP number 1094 of 2023, which was filed for restoration of the second appeal number 5254 of 2020. He has submitted that she was also substituted in the CMP, and thereafter the second appeal has been restored. The names of legal heirs and successors of respondent number 1, proposed legal heirs and successors, has been mentioned in paragraph number 3 of the interlocutory application. पार्टी कौन है रिस्पोंडेंट सिस्टम?
इसमें जैसे इसका ऑर्डर शीट ये एनेक्सर में लगाया हुआ है सीएमपी वाले.
अभी तो एडमिट नहीं हुआ होगा ये.
नहीं अभी तो ये
नहीं हुआ ना एडमिट.
नहीं.
Death notice be issued to the proposed legal heirs and successors of respondent number 1, whose details have been mentioned in paragraph 3 of the interlocutory application, for which requisite under ordinary process be filed by the appellant by 11th of June. The appellant shall also file a registered cover before this court, so that the notices filed under ordinary process be transmitted to the concerned court for service upon the proposed heirs and successors of the respondent. पहले ऑर्डिनरी प्रोसेस का नोटिस बनाएंगे, इसके बाद एनवेलप में डाल के एनवेलप में रजिस्ट्री का स्टैम्प चिपकाएंगे, तब फाइल. यहाँ से नोटिस जाता है, वो लोग ऑर्डिनरी प्रोसेस से ही भेज देते हैं, इसके बाद गुम हो जाता है, इसके बाद नोटिस सर्व नहीं होता. ठीक है. Need will be done by 11 June. Close this case on 31st of July, awaiting service.
Item 5, CMP 1078 of 2022.
such a situation that first notices were served for the proposed legal heirs, my lord. Then the service report came, my lord. Most probably the third person is Dileshwar sir, he has received, is the brother. And the other female family members, my lord, they have either shifted to Barkagaon, some have shifted to Ranchi. On last occasion, my lord, we are not in a situation to find out where they are presently residing, my lord.
You find a substituted service of notice.
Yes, I'll do that.
But जब तक आप किसका substituted service? जब death हो गया है, कौन अभी dead person है यहाँ?
No, my lord, we have filed a substitution, we have filed.
The notice of all addressee have been returned unserved as they do not live at the address given. Right?
Yes.
Notice upon legal year, that is Dileshwar Sao, has been validly served.
He is the son.
Son of the
Kuleshwari Devi, respondent number 28.
respondent number 28.
Rest are my daughter. Ranjish,
आप किसकी तरफ से हैं? दिलेश्वर साव की तरफ से?
they have not filed wakalatnama for Dileshwar, most probably. The rest, everyone has appeared.
नहीं, 21 का वकालतनामा नहीं आया, except 21
No, 21 is no more. There is an order, my lord.
was deleted.
Yes, ma'am.
That's right. और खाली दिलेश्वर साहू का ही बच्चा है. He is not appearing.
No.
तो आप substituted service ले लीजिए ना.
We get a publication
Get it.
for except Dileshwar.
Certainly.
Yes.
Okay. CMP number 1078 of 2022. Counsel for the appellant is present. आप अपना भी एक appearance देंगे. The counsel for the appellant has submitted that notices were issued to the legal years of OP number 28 and one of his legal years, namely Dileshwar Sao, has been served. But so far as others are concerned, the notice has remained unserved as they have left the given address. The learned counsel submits that he is not aware about the present and correct address of the other legal years of opposite party number 28 and prays for them some time to file appropriate petition for substituted service of notice. Let this matter be posted on 11th of June,
11th, my lord, can it be 18th?
on 18th of June,
11th and notice.
18th of June,
Yes, ma'am.
under the heading for orders,
Yes, ma'am. That means, my lord, I have to file a IA for getting it.
substituted. बोलना पड़ेगा, present and correct address पता नहीं है, notice has returned unserved, you have no option but to file. ये सब basic readings होता है substituted
yes.
service of notice का, इसको देखते हुए.
What file has to be followed.
हाँ, yes, that has to be followed. किसी दिन सर्विस ऑफ नोटिस पर कुछ गड़बड़ हो जाएगा तो
I'll be at fault. Can it be on 23rd, my lord?
आपको जब मन
23rd.
इस साल अगला साल 5 साल बाद
जून में ही कर देंगे 23rd.
23 जून
Grateful.